Hi, y'all. How have y'all been? It's been about a week since the ASAP Rocky case ended, and we have so much to catch up on. So much. And it's good stuff. It's good stuff. We've got an update on Young Thug, which I just got a few minutes ago. We have an update on the ASAP Rocky case itself. We're going to look at Relli's original complaints because they are really funny. Like, I'm not even kidding. Like, I was reading them and I was just like, oh my God, what is happening here, Relli? Of course, he's getting the backlash on social media and other places, and the podcast folk, we're all kind of coming for him in a way. So that's going to be interesting. And then we have a lot of Diddy updates, like a ton. We are getting very close to Cinco de Diddy. Cinco de Mayo, May 5th, is Diddy's trial date. Now, here's the thing about Diddy's trial. It's not going to be televised. I mean, come on. So I might have to go to New York for you guys and get the tea. I might have to show up in person and sit there in the gallery and just watch the diddler. But what I love about this channel and legal expertise is there's a lot about strategy leading up to a trial that we can glean from in the way that things are filed. If you guys have not checked out our merch store, it is at av7power.com. And I have shirts for you guys. One of them is Judge Pickles saying, stop! And you guys have been ordering it all weekend. It was amazing. I was like, oh my God, people are buying the stop shirts. And then I got some cute shirts for the girls. Like, look at this. Like, this is in the blush color, which is like in honor of the chair. And this is stitched. It's not like, it's not crap. It's stitched. So if you are interested in merch, go to av7power.com. And I mean, you might be able to get a 20% discount with the code STOP. So shout out to all the people that have been buying those things all weekend. Maybe I will be taking the stop shirts down soon, but I've got the Relli shirts up as well, where it's just like, yes, no, maybe. I don't recall. What are you talking about? What are you talking about? So it's going to be fantastic. Without further delay, guys, let's jump into it. We have quite a bit to catch up on. We have all been watching the ASAP Rocky case, so it's been tough to keep track with all of the different trials that are going on. Before we go anywhere, I want to say hello to a few people. Let's see who we have in the chat. Shout out to Michelle Me, who's just like, I don't know why AV doesn't come up in my notifications. Do me a favor, guys. We're about to destroy the algorithm in a good way, meaning we are going to be posting a lot more often. Whenever you see anything that we post, I want you to look at the little bell on the bottom of your screen. And it's going to say that you're subscribed. You're like, of course, AV, I'm subscribed. Hit the like button while you're at it. But click on that, because what it will default to is customized notifications instead of notifications set to all. A lot of creators are noticing that YouTube went to this default setting. And unless I'm talking about Young Thug or unless I'm talking about ASAP Rocky, y'all just won't be notified. Like, we had 4,000 people in the chat last week. Today we got 256. That's what the algorithm does to your girl. So just to make sure that that setting is on, and it should solve the problem. So thank you so much. Free Thugger, good to see you. Hey, Misty, good to see you. Tyree Lynch, happy Monday. Happy Monday to everybody. Hit the like button. Chi-Town, good to see you, Chi-Town. Is it cold over there? Spring is springing up here in Boston. It was 41 degrees today. Do you know some of this weather? It really does have you feeling like, you're just itching for warm weather. I was like, when is it going to be warmer out? I miss it. I miss warm weather. So we have that, Chi-Town. Thank you so much. Gray's in here. Ace is always in here. Good to see you, Ella. Good to see you, Ella. A. Chelsea. Hi, Chelsea. Hold on. It's Petty Pendergrass. Says we all in this. What up, though? Good to see you. Mark the Paralegal. All my faves. I love this community. Mixed Chick, good to see you, Mixed Chick. Everybody hit that like button. She reminds you. Miss O is in here as well. Just want to catch 2 super chats, guys, and we have a ton of legal documents to catch up on and a little bit of tea. Let's start with Miss Spittin' Fire with the $50 super chat. Thank you so much, Spittin' Fire. And guys, this is a YouTube channel. Sis has been doing it for like, I think she's been in a while, like doing this for a while, like almost years. So do me a favor, check out Spittin' Fire. Definitely a great channel. Says, yes, we need a blogger to go and get the real. Let me know how, and the Fire Flames can assist you on your trip to New York for the Diddy trial. Yeah, you know, we're getting ready for it. I had to have some conversations with my editing team about how we're going to do this because the trial's not televised. You know, guys, we are so used to watching trials like the YSL trial where I can do it from home. We don't need to set up for that. Karen Reed, tomorrow we got a full day of Karen Reed. So for those that have been looking for a Karen Reed fix, it's going to be here tomorrow. The Karen Reed fix is good. We have some pretty long days with Karen Reed, but I do want to keep my thumb on some of these other cases that we've been following, including Diddy, because it's big and we're getting very, very close to that, including this ASAP Rocky thing, because even though the criminal case is over, we're going to talk a little bit today about ASAP Relli and the civil cases. There's a hearing tomorrow on the ASAP Relli one, right? We're gonna jump back in the past, and we got a huge win from Mr. Young Thug. We do. There was a judgment that came out. Miss Whitaker, Judge Whitaker had something come out over the weekend. There were some negotiations that I want to bring you guys up to speed on, so we're going to be talking about that. But for the Diddy trial, yeah, this one's going to be big, and every content creator has to be creative on how they're going to do this. My team's going to do a docuseries for you guys. So we're piecing that together. We even have the documentary for Karen Reed. We're just chopping it up and seeing the best way to present it. Is it a series of 20-minute videos? Or is it just a long ass 1.5 hour thing where you guys see what we put together? I'm excited to chat with you guys because whenever I'm here, what we do is we gather data too. Like how would the viewers want to see it? Do you want to see like a collection of small videos, or do you want to just see one long thing? And with Diddy, we're going to have quite a bit of time. So do me a favor, guys, if y'all could type Spittin' Fire in the chat, that would be fantastic. If any of the mods are hanging around, drop the link to the Spittin' Fire channel and you guys go check it out. You know, always showing love over here. You know, it's been a while. I always love when people support this channel in a big, big way. You know, Spittin' Fire, thank you. Very generous super chat. I appreciate you kicking us off with the tea. All right, guys, the website is on the bottom. AV7thpower.com. Let me just give you the link if you do want to buy merch. The code for 20% off for the trial watching merch it's stop. That's it. It's just like shout out to the judge. Stop is amazing. Anyway, few people we need to follow up with. I will announce this. If you are following the Karen Reed trial, we did lock down Turtle Boy. That's next week. Next Monday, 9 p.m., I believe. We will start advertising all that. We got to start putting our schedule up here so that way you guys know when we're going live. Turtle Boy is going to be here next Monday. Need to follow up with the Brian Steele team. Also need to follow, it's like one other person. Who is it? Melanie Little, following up with her. And then I'm going to reach out to Joe Tacopina one more time. He's doing interviews. I mean, he was on a YouTube channel that did, that was a little bit smaller. I'm like, Joe, we could talk. I could keep up with you, Joe. So that's the update on all of that stuff. But thank you so much, Spittin' Fire. And then coming back to Deonra, been with me for 11 months, D. Wow. 11 months. Says the feds are smart and ruthless. They are. All right, ladies and gentlemen, let's jump into the tea. The first thing that I want to do is go here. And that is looking at, put this all the way over here. We're going to look at an update with Young Thug. This is a consent order. And it was issued on the 21st. So about 3 days old now. Now, this, you guys remember, Young Thug was looking for items that were seized from him, right? He had a watch, he had all this different stuff that the state had seized from him. There was a consent order issued on Friday releasing certain properties subject to claimant Raffaello and Company notice of claim pursuant to that statute. Okay, what happens when you are in a criminal case and people take your assets away? And when I say assets, I don't just mean your house. You know, we're talking about, in Young Thug's case, things were confiscated from his home. Y'all remember Doug Weinstein was like, where's the watch? Where is it? Where's the watch? There were all of these things. People were like, where are his items? And think about that. You work hard, you're rich and famous. And if you are in a situation where you're in legal trouble and your material items in your home, they get seized. We'll talk about that a little bit with Diddy as well, because these items get seized. Now, in Diddy's case, you know, the legal team knew that that was coming. So what they opted for instead is to start selling some of those things. So those assets become liquid, they become money. You sell those things, you get money, and you can put them in a specific place, right? So there's that. Now with Thug, everything happened so fast. He got slapped with the RICCO charge. Luckily for him, he is out, he is free. These past few weeks, he's been doing his thing, making music, collaborating with people. Judge Whitaker also, you know, gave him an opportunity to now travel through the Atlanta airport. Can y'all type Young Thug in the chat? He can move around freely. Maybe there's a few rules, but like a little bit more free from 6 months ago, where he wasn't able to move freely, where he was still incarcerated. So good stuff happening there. But let's check out this document. So this company, Raffaello and Company, plaintiff of the state of Georgia, Jeffrey Williams II, okay, put some respect on that name, individually and as the CEO of YSL Enterprises. Okay, Young Thug. YSL Enterprises consent and agree to an order releasing certain property. The court orders as followed. On July 25th of 2022, Fani and the state of Georgia filed a complaint for forfeiture pursuant to OCGA 9612 against certain personal property, including jewelry, as listed in the addendum to the state's complaint. And claimant Raffaello filed a verified answer to the state's complaint for forfeiture on August 15th, 2022. Claimant Williams filed a verified answer, so shout out to Brian Steele and Keith Adams, for forfeiture on August 25th, so about 10 days later. Raffaello asserts a claim of ownership to certain items listed in the addendum. Specifically, item 18, a Rolex Just Date watch that says King Slime on the rear. I mean, like, that's the other thing. You get this, and if you have his watch, and engraved in it, it says King Slime. That's the King Slime watch. What else do they take? They have a diamond cross pendant, approximately 17 grams. And that's huge, guys. Huge. 17 grams. Next, a necklace with the circular square green jewels, 83 grams of just ice. Wow, that's a lot of money. Item 27, diamond double row tennis necklace. They don't give us the grams on that one. Item 68 or 69, or 69. Why do they put or? 2 diamond stud earrings, 7 grams each earring. Wow. And approximately 4 grams. And item 70, the diamond ring with 13 diamonds on band, with a total of 18 grams. So keep in mind, chat, we still don't know where is the watch. We need to just, maybe the next piece of merch should be like a milk carton with Doug's watch on it. And it should say, where's Slime's watch? Where is it? Where? We don't see it. Interesting. Moving along, Williams, in his answers for the state's complaint for forfeiture, asserted a claim of ownership of items of jewelry numbered above on Addendum A to the state's complaint. And Raffaello, Williams, and the states agree to an order releasing the property below of the Council of Record. So it looks like he's going to get his stuff back. He's getting the King Slime Rolex back, the diamond cross pendant, the necklace with the circular and square green jewels, diamond double row tennis necklace, 68 or 69, to be determined after inspection by Raffaello. And that's the other thing. You guys remember the joke? Satan 68. Is it Detective Dennis involved in this at all? I mean, is it 68 or 69? Which one? Item 70, a diamond ring with 13 diamonds. Whereas the state hereby consents to the release and return of the property identified above in accordance with the terms contained therein. Raffaello, Williams, and the state are not aware of any other person or entity that has claim or interest to this property. The court hereby orders the release of the property identified above to Aurora to act as a receiver and said property to facilitate the agreement reached by Raffaello and Williams. This consent order will serve as a final judgment only as to the defendant's personal property specified above. So what this is Judge Whitaker signing this, and it's not everything that they took from Young Thug. There are pieces of things. This seems like it's more of a jewelry inventory, because if we go to the top, you have $149,426 in US currency. You see that number right here that I have highlighted? That's how much they took in cash, right? They took a 2022 Chevy Corvette. They took a 2022 Porsche 911. They took a 2021 Mercedes-Benz GLS Maybach. They took a 2021 Mercedes-Benz EMG. They took a gray Mercedes-Benz AMG GT. They took a Jeep Grand Cherokee for the economic people in the back, for a Dodge Durango for the economic people in the back, a 2018 Lambo, a 2015 Spider, a Glock 19X firearm, a Glock 45 firearm, a 5.7 firearm, a Smith & Wesson, a Glock 357, a Glock 30S, 45, and an assorted jewelry described in Addendum A. So what we just looked at, guys, this is all the jewelry described in Addendum A. But how many cars is this? 1, here's a VIN, 2, 3, 4, 5, 6, 7, 8, 9 goddamn cars. They took 9 cars. They took 9 cars from Young Thug. 9. Let's just talk. Let's act as if we're Kelly Blue Book in Carfax right now. 9 vehicles they took from Young Thug. Some of them are luxury. Some of them are Lambos, things of the like. The guns, he pled guilty to having those. But the cars, Young Thug is working right now. But if you think about what the state has in its possession, 9 cars is almost upwards of $1 million in assets. That's being super, super, super like, okay, let's be nice about it. Even if you were to be conservative and like squeeze that budget down, that's still like $700-800. Give this ninja his cars back. Like, what are we doing? Like 9 cars, 9. Some of them are Durangos and Cherokees and things of the like. I get that. But when you're taking my rights away as a person and you're saying I'm this big bad king slime, big bad wolf, and I should be locked behind bars and y'all don't have no real evidence, finally get out of jail, finally can travel again and make money again. I'm going to donate. You practically took my First Amendment rights away because I can't swear in songs. I can't talk about the streets in songs anymore. Wow, what an impediment on free speech. But y'all still got these 9 cars. Like, what? So at least in this document, we see that he is getting his jewelry back. So this came across my desk this morning. I thought it was super interesting. Wanted to show you guys. Coming to Super Chats real quick and we'll move on to the next topic. But that's what we have on Young Thug so far. He's doing shows. He's doing his thing. Shout out to Thugger Daily. If you want the update, I really appreciate Thugger Daily because they're still showing Young Thug's movements, everything he's been involved in. Brian still got a song made about him. Like it's pretty cool. Drake has been involved. Like Future has been doing some collabs with Young Thug. So we are just happy that Young Thug is home. He's doing his thing. He's with his family and enjoying life. Enjoying life, right? Coming to a few supers and then we'll move on to all of the Relli shit. I was researching this morning, guys. I was like, oh my God, Relli. Because it's not over. You have the civil case, but you still have the criminal case. And when I say civil case, there's actually 2. Y'all remember Relli's shells? I threw that bag away over the weekend. I'm like, I don't know if I'm going to need it anymore. Detective Relli went and picked up some shells, and he's being dragged on the internet ever since the criminal case has been lost, because many people are now wondering, well, what happens to these civil cases now that the criminal case was lost? If a jury cannot convict ASAP Rocky of assault charges, can you still apply assault charges on the civil side? We're going to talk about that. Shout out to Deanna, who hits me with a 5, says the Fed's playing hardball with Diddy. He's on 2nd and 3rd lawyer. Oh, we're going to talk about that. There is a Twitter page that I quite enjoy watching or reading. And it's the Diddy docket. Y'all go check them out. I really enjoy checking out the Diddy docket because it's like the Thugger Daily for the Diddy cases. There is a plethora of Diddy cases. There's so many of them. We have content for days, but it's not even about that. It's really just with this major criminal case. It's kind of like the YSL RICCO case and the ASAP Rocky in a case, in a sense, because you have all these intricacies that are related to them. Right? But yeah, so we're going to see what the feds are doing with Diddy. They are playing a little bit of hardball, but I wonder why one of his attorneys withdrew. Speaking of ASAP Rocky, Joe Tacopina at one point was Trump's lawyer, and he withdrew from Trump's case as well and was perfectly fine, went on and going about his business. But we are going to look at that document because there is an interesting quote in there. So thank you, Dion Ryan. He hits me with another 2. He says, Fulton County playing Debo with what you got my 40. There 9 cars. 9. And when Thug got arrested, I believe it was May of 2022. So all of those cars were new. They were all the same year. Like if we're Kelly Blue booking it, that's a lot. It really is a lot of money. Anyway, that covers Young Thug. All right. Diddy's going to take a while. So, and shout out to Audrey popping in. She is popping in saying, never want to go through full. And thank you so much, Audrey, for the $10 super chat. And thank you just for being with me for so long. I think it's been a while that you've been following my channel, just been such a diehard supporter, subscriber. I can't thank you enough for your time with me. But she says, never want to go through full. And well, now we see why. Miss faniwillis, which we'll talk about as well. She has to stop dodging subpoenas. I wish, and I'm sure you do too, dear citizen watching, or even if you're not a citizen, I wish we could just dodge subpoenas. Like we could just matrix. Like I don't have to go to court. I am the elected Fulton County District Attorney. Why do I need to go to court? I wish I can answer court documents like that or ignore them. This woman can. But a judge in Fulton County is like, no more. We're done with this. But anywho, thank you, Audrey. And shout out to everybody popping in. I love that you guys all pop in at different times. All right. Let us now switch gears. We are going to talk about this. This I thought was so interesting. Y'all know Mr. ASAP Relli, right? And let's see if we can zoom in so all y'all can follow along. ASAP Relli is the gentleman that was involved with the situation with ASAP Rocky. We just finished that trial last week. ASAP Rocky was not convicted. Jury members came out and said, listen, we believe that a crime was committed. Shout out to Neek at Night. I believe she was the one who actually got a jury member to come out and speak. She interviewed her. They believed that a crime was committed. At the end of the day, you have ASAP Relli alleging, because we still couldn't see it, that ASAP Rocky pulled out a gun on him, which appeared to be a prop gun and was said to be a prop gun. Did we have that prop gun in evidence? No. We had a judge screaming, stop. Relli did not help himself by being on the stand and disrespecting the judge and just not being a pleasant witness. Joe Tacopina has been in a lot of places talking about this case, talking about Relli's performance, talking about Relli lying and how he even went through the setup process of how he was catching Relli in these lies. And they were very confident in this case day one. I really want to get him on here, but we'll see if he bites. Now, you had actually three complaints altogether. You have this criminal complaint, which is the charges, right? But you also have two cases in the background civilly that Relli has filed. I got both of these documents right here, and I can't wait to look at them because here's the thing. They were filed in August of 2022. This incident happened in November of 2021. So realize that these civil actions happened a few months after the criminal actions happened. You know, they raided Rocky's house, not even raided, but they completed a search warrant in April of 2022. And then, lo and behold, what we're looking at here, and let me just fix it for y'all. This complaint was filed by Relli and his attorneys at the time in August of 2022. So after all of this happens, Terrell Efron sues Rakeem Mayers, right? Individually. So this is Relli suing Rocky. This is the first one. You know what else I have for you guys? I have the other one as well. I have both of them. I was like a deep sea detective today. I just went on a legal binge of looking at this, and Camille Vasquez and Ben Chu, their names. The names must be named. Their names are on this document. So you have this one right here where Relli is suing Rocky by himself for what? Assault, battery, intentional infliction of emotional distress, negligence, and negligence per se. Then you have this one where he's suing Joe Tacopina individually. He's suing Tacopina's law firm and Rocky. This one is just for defamation. So you have this civil action, and Camille and them, they're representing Relli on both of these. But you see one that has assault, battery, intentional infliction of emotional distress, negligence, and negligence per se, just with Rocky by himself. And you got this other one for defamation. What does that mean? Defamation. You said something about me that's not true, and I don't like it. So, and think about it for this third stop of the case where you have Judge Pickles standing in front of these gentlemen saying, stop. That's why it was so heated in the courtroom, because Joe Tacopina is listed as a defendant in this civil crime or case. Sorry, not crime, case. Interesting, right? So I went down a whole rabbit hole because he's suing for $30 million in both suits. Which suit? The fact that you're coming after Tacopina by himself and his law firm, that's interesting, interested to me. Did I say, yes, intentional infliction of emotional distress. Do y'all remember? And that's called IIED. It's actually a tort. Do y'all remember what Relli's injuries looked like? Do you guys remember the knuckles? The permanent damage, permanent irreparable damage that can never be fixed. Permanent irreparable damage. I'm just opening the image in a new tab so y'all can see it. Y'all remember this? Permanent irreparable damage. This is what did it. Relli is suing for $30 million for this. Put a 1 in the chat if you've ever had an injury like this. Put a 2 in the chat if you've never had an injury like this. I think when I was a kid, I fell a few times when I was 5, 6 years old outside playing on my bike, riding a bike, probably fell off the bike, got some scrapes on the knuckles, just like this. Just like this. On the knees. Everybody falls off their bike. People get scrapes and scratches like this. I don't know, maybe you're an angry child, you punch a wall. I don't know. But is this permanent, irreparable damage where you'll never be able to use your digits again? You will never be able to bend that index finger. You will never be able to bend that middle finger. You'll never be able to use that ringer finger, that ring finger, or you'll never be able to use your pinky finger. It won't bend. It won't move. Permanent, irreparable damage. In the law, that's what that means to me. Permanent, like I'm moving it. It works. Permanent, irreparable damage means it ain't working. Ringer finger is crazy. That was crazy work, Freddie. Ringer finger. It's, I mean, and he wanted $30 million for this. Some of y'all are like, all he needs is some lotion, but the scrapes, Destin, the scrapes and the scratches, you got to make them look good. The same man that was supposed to go to the hospital, you got to make this look good. You got to make it, forget the lotion that day. Forget the cocoa butter. Why would you put them on your hands where you're trying to show permanent, irreparable damage? Why? Michael, I was thinking it. I wasn't going to say it, Michael. I mean, I don't. Anyway, let's look at the original documents, the original receipts from 2022, the two complaints. Are y'all ready? Let's look at the first one. So the first one, this is the one that is just Rocky by himself, okay? So he is suing Rocky for assault, battery, intentional infliction of emotional distress, and negligence per se. Now, Mr. Efron complains of the defendants and each of them for a cause of action as follows. Plaintiff Relli Efron is an individual and is now and at all times therein was present in the city of Hollywood, County of LA, State of California, at all times material to this action when the incident took place. Plaintiff is informed and believes, upon such information and belief, alleges that at all times material to this action, Rocky resided in LA, in the state of California. Relli is informed and believes, and thereon alleges that at all times material to this action, those 1 through 15 are individuals and resided within County of LA, State of California. Relli is unaware at this time of the true names and capacities, whether individual, corporate, associate, governmental, or otherwise, those other defendants sued here, those 1 through 15, inclusive, and therefore sues the defendants using their fictitious names. Let me go back up, because is he suing some? Oh, actually, he's suing Rocky and John Doe's 1 through 15. So there are 15 other people that he's listing in here. Does that include Ills? Does that include, oh my God, I always forget his name. It's not ASAP Ills. What's the other one's name? The one with the braids. The nice one. Oh, 12E. So it's Rocky and 15 other individuals named John Doe. Usually whenever they do Does, it's because they're trying to conceal the person's name. Wally, 12E. There's a few other ones. Thank you, guys. Relli needs to sue the LAPD. Well, isn't Relli part of the LAPD? Isn't he? He's gone and collecting shells and bagging and tagging evidence and then bringing it to them, and they just took him for his word. Deleting text messages, all types of shenanigans. Interesting. I didn't realize that it said John Doe's 1 through 15. So there's 15 other people. Plaintiff will amend this complaint to include the true names and capacities of these defendants when the information becomes known. Plaintiff is informed, believes, and thereon alleges that each of the defendants designated here as Doe was negligent and is otherwise legally responsible in some manner for the events and happening referred to in this complaint. All right, here's the best part. Here's Relli's factual allegations. Based on information and belief, at the time of the incident and at all times referenced therein, Rocky was a prominent recording artist and producer for RCA Records, Sony Music, ASAP Worldwide, and Polo Grounds Music. On or around November 6, 2021, Rocky contacted Relli and requested to meet Relli at Relli's location in Hollywood. On or around November 6th, Rocky, in fact, met up with Relli in Hollywood and initiated a verbal altercation. During this altercation, and while in close proximity to Relli, Rocky pulled out a handgun and purposefully pointed it in the direction of Relli and fired multiple shots. Now, this is interesting because this is Relli's complaint. And this shows that when this was filed, Relli's not calling it a prop gun. He's calling it a handgun. Like, he's calling it a handgun. Interesting. Upon seeing Rocky produce and point the handgun in Relli's direction, Relli was in immediate fear for his life. As a result of Rocky firing the handgun at Relli, Relli was struck by the bullet projectile fragments, which required Relli to seek necessary medical attention. A large portion of the incident was captured on video. I mean, large. I mean, we saw the criminal trial last week, guys. A large portion of this, larger than life, a large portion of this was captured on video. We saw blurry images. What are you talking about? What is that? This is funny. Following an investigation by the LA Police Department, the defendant was arrested. Okay, that's it. Look at how light that is. 11 lines, 11. General allegations, 11. This is a very light complaint. First cause of action, assault against all defendants in Doe's. Relli realleges and incorporates by reference here, as though fully set forth paragraphs 1 through 11 of this complaint. And these are the paragraphs, guys. These look like lines to me, but these are the paragraphs. These light general allegations is what Relli based his whole thing off of. Let's look at that section. In allegations, you have 1, 2, 3, 4, 5, 6, 7. 7 very tiny paragraphs to back it. Why do y'all drag me into this? Why are we reading this? Let's keep going. Okay, first cause of action, assault. Plaintiff realleges and incorporates by reference here as though fully set forth paragraphs 1 through 11 of this complaint. Defendant purposely or with reckless disregard brandished a firearm in close proximity to the plaintiff in a threatening and menacing manner. Defendant purposefully and with reckless disregard raised the firearm in a threatening manner towards Relli, thereby threatening Relli, such that any reasonable person in plaintiff's position would have been placed in immediate fear of grievous bodily harm. As a result of being placed in fear of immediate grievous bodily harm, Relli suffered and continues to suffer physical, mental, and emotional injuries. Let me say it again. Because being placed in fear, Relli suffered and continues to suffer physical, mental, and emotional injuries. Relli alleges that the acts and omissions of Rocky were willful, malicious, intentional, oppressive, reckless, and were done in conscious disregard of Relli's rights, his welfare, his safety, thereby justifying an award of punitive and exemplary damages in the amount to be determined at trial. So Relli, stop. Relli, you're telling us that because you were afraid, that the acts and omissions, acts meaning things that Rocky did, omissions, things that Rocky didn't say, that these were willful, malicious, intentional, oppressive, reckless, and were done in conscious disregard of Relli's rights, his welfare, and his safety. And because of that, it justifies a punitive award, a punitive meaning designed to punish, exemplary damages, meaning big amounts of money, to be determined at trial. Now, we talked about this during the trial last week, guys. It, was on camera, the moment where Rocky pulled out the gun, prop gun, whatever it is. Assault all day. Assault. Does it still succeed now that the criminal cases fell through? Don't know. I don't think so. I think it's an automatic, there's some type of judgment that happens where this is probably not going to succeed. But it is interesting to watch, right? Second cause of action, battery. I don't think he has this. What is battery? I got confused about this in law school when I first started. I thought assault meant battery. Battery is the touching, the offensive touching, like hurting somebody, hitting them, putting your hands on somebody else. Battery is that part. Now, in the video, you do see them holding each other up right here by the hoodies up on the chest. That's the battery part that I assume we're about to get into. But let's talk about that a little bit. Here, Relli realleges and incorporates by reference here as though fully set forth in paragraphs 1 through 16 of this complaint. Rocky purposefully or with reckless disregard pointed a loaded firearm. How did he know it was loaded? Pointed a loaded firearm at Relli and pulled the trigger, causing a bullet projectile / fragment to contact Relli's person, such that any reasonable person would be offended or otherwise harmed by contact. Rocky purposefully or with reckless disregard intended by and through his actions to cause the plaintiff physiological, mental, and emotional harm. By and through his actions, Rocky, by and through the actions of Rocky, Relli suffered physiological, mental, and emotional harm. Says it again. Plaintiff alleges that the acts and omissions of the defendant was willful, malicious, intentional, oppressive, reckless, and were done in conscious disregard of the plaintiff's rights, welfare, and safety, thereby justifying an award, again, there's some money, of punitive designed to punish and exemplary damages, big money, in the amount to be determined by trial. So far we see assault. Second, we see battery. Now we're coming to, I can't stand this one, intentional infliction of emotional distress. Relli realleges and incorporates by reference here, as though fully set forth, paragraphs 1 through 22 of this complaint. Defendant purposefully, Rocky purposefully and with reckless disregard, unlawfully brandished a firearm towards the plaintiff. Further, Rocky purposefully or with reckless disregard caused a bullet projectile fragment to hit Relli. In both instances, Rocky's conduct was unlawful or otherwise extreme and outrageous. In every instance set forth above, Rocky intended to cause the plaintiff, Relli, severe emotional distress and otherwise knew or should have known that the plaintiff would suffer. You should have known that Relli was going to suffer this severe emotional distress. As a result of his interactions with the defendant, the plaintiff suffered and continues to suffer severe emotional distress and was prevented from attending his usual occupation. Wait. Because of this emotional distress, Relli wasn't able to work. I mean, he did say he lost jobs. He did say that he lost clients. He did say that. I'll give him that one. But because of this emotional distress, he was not able to work. Let us continue. Relli's damages, therefore, are unknown to them at this time. And when ascertained, an amendment to this complaint will be made. They're missing a punctuation mark. Relli further alleges that the acts and omissions of the defendants were willful, malicious, intentional, oppressive, reckless, blah, blah, blah. And he wants some money. He wants punitive damages and exemplary damages in the amount to be determined at trial. Next, fourth cause of action, negligence and negligence per se. Plaintiff realleges and incorporates by reference here, as though fully set forth, paragraphs 1 through 28. Under penal code, this is California law, it is illegal to commit assault upon another person with a firearm. But that's the other thing, like we have issues on whether or not it's classified as an actual firearm. Defendant violated this law when he unlawfully aimed a loaded firearm and pointed it at the direction of the plaintiff. This action was a substantial factor in causing the plaintiff to suffer physiological, mental, and emotional harm. The physiological, mental, and emotional harm suffered was the exact harm that this law is designed to prevent. Rocky acted without legal justification or excuse when violating this law. Wherefore, Relli prays for a judgment against Rocky and each of the 15 people that hurt him. He wants general damages exceeding $25,000 to be proved at the time of trial. He wants damages for x-rays, medical, future medical, and sundry expenses as may be proved. For prejudgment interest allowed pursuant to these codes and any interest allowed by law. He wants loss of earnings and earning capacity as may be proved. He wants punitive damages designed to punish to be proved at the time of trial. The cost of what this lawsuit cost him. The cost of suit incurred herein is what we call it, for other and further relief as this court might deem just and proper. That's the first one. Brian Hurwitz was his attorney at that time. It was another gentleman, could be a woman. Oh, nope, it's a guy, Jamal Tucson. Those were Relli's original lawyers. What do y'all think? What do y'all think? That's the first lawsuit. That's against Rocky and the John Does for assault, battery, intentional infliction of emotional distress, and negligence. Wait till we look at the Tucapino one. Hi, allegedly, maybe. Mixed Chick says Relli has lost his mind and needs to be in a padded room ASAP. I mean, yeah. I mean, his hands still move. I don't know. For me, it's like, where is the permanent irreparable damages? Maybe your medical expenses, that's a small claims court thing. To bring this and after the criminal trial where we saw him say things like, you know, I want this ninja's money, and, you know, they got to fine me for the case. I don't have to attend. I don't have to go to the court proceedings. Like, it just feels like it was a gang from the jump. Mark the paralegal says, I wonder if Relli was high or something, because I've only seen 4 people in that video, not 15. Well, you know, Mark the paralegal, sometimes you can come after businesses, but it does say John Does. So let's think about this. You got 3 guys that are on the scene. Rocky, aside from Relli, Rocky, Ills, and 12E. That's 3. Then you have the other gentleman that recorded the phone calls. That could be 4. Then you have the manager. That could be 5. But to your point, that's 5 people. Where's the other 8? Who else contributed to all of this? Where are the other 8 people? Shout out to Don't Fuck With Justice, who was in the chat. Listen, we've been talking on Twitter about this quite a bit. And I just found these documents so fascinating. Like, I just went on like a binge this morning to like dig these up and look at them. So, you know, these documents have been amended, guys. So I looked at the original complaints, like when Relli filed these. What was the thought process? What happened? A lot of folks from Twitter popping in. Shout out to Dennis Byron, who's in here as well. Shout out to Dennis Byron, the heart and soul behind the Hip Hop Inquirer brand. He does his thing as well. But we're just looking at both of these. Shout out to I Am Thankful, who says, somebody tell Relli to sit his Drake ass down. We're going to talk about that once we get to the Diddy docs today, guys. Because here's the thing. The legal system, and I think it really started last year with a lot of the heavy lawsuits we started seeing against, at the time, former President Trump, today President Trump. And that's where lawfare became a thing. You know, at first we were like, is it just a political thing? But then we're seeing Drake sue UMG. Then you're seeing 50 Cent come at Megan Kunef. And he's just like, I want my money by Monday. Today is Monday. Where's the money, Megan? I don't know. And shout out to Megan. I've never had any issues with her or anything. But when I saw that post, I was just like, the times of YouTubers colliding with people in the more bigger space, media space, are interesting. That's where we are. That's where we are. Deonra says, Relli, don't go out this sad, bro. Yeah, I mean, it's happening. So that's the first one. Now, let's talk about defamation, where we see Relli come back. And this time he's suing Joe Tacopina himself as an individual. He's suing Joe Tacopina's law firm, a New York corporation. Rocky, an individual. And shout out to those that realize this. In this one, we have John Doe's 1 through 50. 50! Not 15, 50. I mean, this is interesting. So 50. Let's read this one. It is a little bit longer. I'm going to skip through the procedural parts, some of the standard things. You know, we talk about this in, lawsuits from time to time. Like the beginning usually is like subject matter jurisdiction, personal jurisdiction, venue, all of that being right. Like who are the parties in the case? So I'm going to skip through some of that fluff. I do really want to focus on the factual allegations here. And then we will jump towards the new Diddy filings as well. Kelly Kell, our favorite 2L in law school, says, I'm not saying I support violence, but does this make Relli seem so soft? Like, did you die though? No, but he did get these. He got these, Kelly Cow. We all fell off our bike when we were little. He got these. Interesting. But let us jump in. So, Relli is in support of his complaint against Tacopina, his law firm, Tacopina Law, Rocky, and Doe's 1 through 50. Right? All of these people are going to be known as the defendants. Nature of the action. So again, we're talking about the facts here. November 6th, Rocky, also known as ASAP Rocky, brandished, aimed, and fired multiple shots from a semi-automatic firearm at the plaintiff, injuring Relli. A large portion of the incident, he says it again. Let's go to the back. What day was this filed? I just want the filing date just to be sure, because that other one was August of 2022. My bad, you guys. There's a lot of exhibits back here. The exhibits include TMZ articles. This is filed by Camille a month later on September 11th. Actually, a year later, September 11, 23. Okay, so the first defamation claim was in August of 2022. This defamation claim came a year later, and it's probably because of some of the statements that were made. But, wow. Interessante. All right, coming to the top. A large portion of the incident, in particular, the shooting, was captured on video. Rocky was subsequently detained and charged with 2 felony counts of assault with a deadly weapon, a felony with a potentially custodial sentence of 9 years. He is awaiting trial. Relli brought a civil action against Rocky, alleging causes of action for assault and other torts. In response to Relli's lawsuit, defendants commenced a press campaign to impugn and malign Relli, painting him in the press as a liar, a money grabber, and a blackmailer. Mr. Tacopina, acting in his capacity as an attorney at Tacopina Law and acting on behalf of and at the direction of Mr. Mayers, gave several interviews in which he stated without limitation the following. Here are the statements, y'all. Are y'all ready? Rocky didn't commit a crime. It was an extortion attempt by a former associate who threatened to make false criminal accusations if Rocky didn't pay him. Oof. Next. Tacopina has 2 eyewitnesses who back Rocky's story. That's right, Ills and Twelvey. Not only that Relli wasn't hit by the bullet fragments, but that no shot was even fired. Well, the prop gun theory has entered the chat. Hello, prop gun theory. How are you? It has entered the chat. Relli has made the story in a get-rich-quick scheme. Rocky is the victim of a failed shakedown and fabricated shooting accusation orchestrated by his jealous former friend, ASAP Relli. Rocky didn't shoot Relli by any stretch. These are all in quotes. Sometimes they forget quotation marks. The incident was a false scenario at the heart of a plain and blatant classic attempt at extortion. Plaintiff had been badgering Rocky for money before he had allegedly initiated a physical altercation at a face-to-face meeting and then tried to spin the confrontation into a shooting claim. Relli is a failed associate, ex-associate of Rocky's, and he is jealous. Relli was trying to get money from Rocky. He wanted Rocky to support him. He made it clear. There were repeated attempts where he tried to ask for money in lieu of not causing problems for Rocky. That's what he said. We have all of this memorialized in text messages and otherwise. So it's an extortion. Relli tried to attack Rocky and some other guy not involved, and he punched some other guy in the face and knocked his teeth out. And of course, now, according to him, he's a victim. Go, Tacopina, cook. Rocky has been accused of assaulting someone with a gun, a former friend of his, someone who clearly became jealous of Rocky and accused him of assaulting him with a gun. I will tell you this, if they don't dismiss this case, we will be going to trial because he is not guilty. It is an extortion play. I have proof of extortion before the charges were brought. He's asking for millions and millions of dollars. We have this memorialized rock solid, and it's a shame they bought this case. These statements were published far and wide, initially with print media, Rolling Stone and TMZ, and later on a show called Sid and Friends in the Morning. Several other news media outlets republished the defendant's propaganda. The statements above were false, malicious, and have caused the plaintiff extreme reputational, emotional, and financial harm that must be remedied. Ooh-wee. Well, ladies and gentlemen, that is the start to the second document, which is really not happy with the Tacopina firm statements. That's it. That's it. And legally, when you're representing a client as an attorney, you can speak to the public about an ongoing case. Does it come with its risks? Yes. We're about to talk about Diddy and Jay-Z and all of that. But like, look at what happened when Tony Busby puts his witness, not even witness, his client, Jane Doe, on the news and there are multiple inconsistencies with the story at the heart of the matter, it turned into a media circus. And we're going to probably do that later this week. Jay-Z suing Busby himself. I've got that too. That's been happening in the back burner. That number, like that case, Jane Doe versus, Diddy and Sean Carter, has been dropped. She has withdrawn her charges, all of those things. However, it didn't stop Jay-Z from going back after Busby, like, here's what you did and said about me, and I will have my day in court. Crazy. Anywho, you can have discussions about this. Now, when we got to the criminal case, you guys remember Judge Pickles? Stop! He did say that he did not want any attorneys, whether on the prosecution side, Lanyard Lewin, or Joe Tacopina and team, to do interviews. And right before the jury started deliberating, who comes out and they're like, no, he did an interview. It's not fair. And it's just like, okay. That would be Lanyard Lewin at that point. However, if the state were to do it, would you get a $30 million defamation lawsuit? Would you get it? I don't know if you would. Craziness. All right. Parties I'm going to skip over because we know who these folks are. Jurisdiction and venue, we're going to skip over. All right, let's get into the tea. The general allegations. That being said, take a sip of the tea. Starting with ASAP Mob. Relli and Rocky are recording artists that are a part of a musical group known as ASAP Mob, with ASAP representing the model, Always Strive and Prosper. Members of ASAP Mob are also known by their stage names preceded by the ASAP prefix. Mr. Mayers is known as ASAP Rocky, and plaintiff is known as ASAP Relli. Mr. Mayers shoots victim. Shoots. Interesting verbiage. On November 6th, Rocky contacted Relli and requested to meet in LA. Rocky then proceeded to meet with Relli at his location in the Hollywood area. Rocky initiated a verbal altercation and subsequently pulled out a handgun and pointed it at Relli. Rocky fired multiple shots at Relli, which resulted in Relli being struck by a bullet projectile and fragments that caused Relli's injury. Rocky then fled the scene on foot. A large portion of the incident, and importantly, Rocky shooting the plaintiff, was captured by video. I can't stand that they keep saying a large portion of the incident. Whatever. Rocky is criminally charged. Following an investigation of the incident by the LAPD, on April 20th, Rocky was apprehended at the LA airport, LAX, after returning from Barbados. On the same day, a search warrant was executed at his home. On August 15th, Rocky was criminally charged with 2 counts of assault with a deadly weapon. Notice that it says a semi-automatic firearm. A semi-automatic firearm. And don't worry, for always, forever, for life. I'm going to keep you guys updated with that. I have all those Diddy docs. So after this, we'll look at them. A felony that carries a potential custodial sentence of 9 years. In connection with these charges, District Attorney George Gascon stated, discharging a gun in a public place is a serious offense that could have ended with the tragic consequences not only for the person targeted, but for innocent bystanders visiting Hollywood. My office conducted a thorough review of the evidence of this case and determined that the addition of a special firearm allegation was warranted. Relli sues Rocky on August 10th. So hang on, this is August 10th. Relli sues Rocky on August 10th. Rocky wasn't criminally charged until the 15th. 5 days later. So this lawsuit came in before Rocky was criminally charged. Anyway, Relli filed a civil action in the Superior Court of the State of California, alleging the following causes of action: the assault, the battery, IIED, negligence. In the assault action, plaintiff alleged that he was shot. He was shot by Rocky, and that Relli was required to seek medical attention for his injuries sustained as a result of Rocky discharging the firearm. Furthermore, Relli alleges that he was in fear of his life when Rocky brandished the firearm, pointing it at him, discharging several shots, and ultimately injured Relli. Relli alleges that he was experiencing severe emotional distress. Okay, how does Joe Tacopina get involved in all this? Tacopina defends Rocky. On September 15th, Mr. Tacopina, through the Tacopina Law firm, filed a general denial of the plaintiff's complaint on Rocky's behalf. On September 19th, Tacopina, through the Tacopina Law, filed an application in LSAC to be admitted pro hoc vice as an attorney of record for Rocky in the assault action. On October 12th, Mr. Tacopina's pro hoc vice application was granted. And we've talked about that, guys. And once we get to the Diddy stuff, we'll talk about pro hoc vice and what it means, Latin terms. Basically, if you are not barred in a specific state, but you want to be temporarily barred there to represent one of your clients, you can do that. It's the concept of pro hoc vice. There's some terms that come with it. You do have to work with other local attorneys to help make that happen. But we see that all the time. All right, let's talk about this defamation thing. Notwithstanding the LAPD's detailed investigation and the pending felony charges against Rocky, defendants commenced a campaign of malicious lies to various media sources, falsely painting Relli as, among other things, a liar, a blackmailer, an extortionist, and a money grabber. Specifically, Rocky, through his attorneys and agents, including specifically the Tacopina defendants, has published defamatory statements as outlined below. So we're going to go into the first one, which is TMZ. Relli is upset about this TMZ article. On or about September 16th, Mr. Tacopina acting in, you know what, just gave me a flashback. This reminds me of Lanyard Lewin complaining about TMZ day one of this trial. Reading this is an interesting flashback. Let's go. So Mr. Tacopina, acting in his capacity as an attorney at Tacopina Law and acting on behalf of and at the direction of Mr. Myers, gave an interview to news media publication TMZ that was printed in an article titled "ASAP Rocky, I Never Shot Him. It's an Extortion Attempt." A true and correct copy of the TMZ article is attached hereto as Exhibit A. The article opens, "ASAP Rocky is clear, and he did not shoot ASAP Relli," pushing back against his accuser, whom Rocky says it was simply trying to make a cash grab. In the TMZ article, Mr. Tacopina is reported as stating that Rocky didn't commit a crime. It was extortion attempt by a former associate who threatened to make false criminal accusations if Rocky did not pay him. If. And we've seen those text messages, you guys. If, right? Tacopina further stated that he has two eyewitnesses who back Rocky's story, not only that Relli was hit by fragments, but shots weren't even fired. In other words, the TMZ article concludes that Relli has made the story in a get-rich-quick scheme. The explicit and implicit message communicated by Tacopina was that the plaintiff is a liar, Rocky didn't shoot Relli or discharge a firearm, plaintiff was not injured, blah, 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 blah. That's the first one. So you have the TMZ article. Let's go to the second one, Rolling Stone. On the same day, Rolling Stone published something. Tacopina, acting in his capacity on behalf of Rocky, gave an interview to the news media publication Rolling Stone, and it was printed in part of an article authored by Nancy Dilly entitled "ASAP Rocky Lawyer Says Jealous ASAP Relli Fabricated Shooting in an Attempt at Extortion." I hope they don't have this woman listed. They might. A true and correct copy of this article is attached as Exhibit 2. In the Rolling Stone article, Tacopina is reported as stating that ASAP Rocky is a victim of a failed shakedown and fabricated shooting accusation orchestrated by his jealous former friend Relli. It's the same, more of the same. Saying that he didn't shoot him by any stretch. It's a false scenario. Relli had been badgering Rocky for money before he initiated the physical altercation. It's more of the same, guys. He's just jealous. He wants money from Rocky. More of the same. Tacopina further stated to the Rolling Stone that the plaintiff, and not Rocky, was the aggressor. He said that he tried to attack Rocky and some other guy not involved, and he punched the other guy in the face, knocked his teeth out, and of course now he's a victim. The explicit and implicit message communicated by Mr. Tacopina, acting in his capacity as agent and attorney for Mr. Mayers, was that 1, plaintiff is a liar. 2, Rocky did not shoot him. And 3, Relli fabricated. Relli lied about the incident. Relli initiated the altercation and was the aggressor. Relli was attempted to extort Rocky, and Relli threatened to make false accusations unless paid by Rocky. And I mean, Tacopina didn't lie about this. They had text messages with him saying, I want this ninja's money. They had those, even at the time of this. Because you know where those came from? Relli's phone. Copy of Relli's phone. Tacopina was talking about it. We got the copies of it from Relli's phone. Defendants' defamatory statements are republished. Defendants' blatant lies in the TMZ article and Rolling Stone article spread far and wide and were reprinted and republished to several publications, including without limitation the following. Vibe magazine. ASAP Rocky's lawyer calls alleged shooting claim an extortion attempt. BET. I'm so done. ASAP Rocky's lawyer says ASAP Relli fabricated shooting to extort him. They also added Relli is jealous. The Root. ASAP Rocky responds to the shooting case allegations. SOHH, Complex, Daily Mail. Relli is not happy because of 1, 2, 3, 4, 5, 6 articles. In particular, Tacopina Law republished a TMZ article. They did. I saw it this morning. And Rolling Stone article on its website, thereby adopting and ratifying Tacopina's statements contained therein. Camille Vasquez signed this. Brown and Rudnick signed this. This is a very reputable big law firm. And when I say big law, I mean like there are small law firms, there are mid-sized law firms, and there are big law firms. Johnny Depp's attorney. Radio interview. There's more. Tacopina, acting in his capacity as attorney at Tacopina Law and acting on behalf and at the direction of Rocky, gave an interview on a radio show called Sid and Friends in the Morning. In the radio interview, Tacopina stated the following. Rocky has been accused of assaulting someone with a gun, a former friend of his, someone who clearly became jealous of Rocky and accused him of assaulting him with a gun. I will tell you this, if they don't dismiss this case, we will be going to trial because he is not guilty. It's a clear extortion play. I have proof of extortion before the charges were even bought. He's asking for millions and millions of dollars. We have this memorialized, rock solid, and it's a shame they bought this case. This message communicated by Tacopina in the context of this court cases against plaintiff was that plaintiff was a liar. Rocky did not shoot him. More of the same. Relli receives death threats and suffers emotional distress as a result of the defendant's publication, which they did not publish themselves unless you look at them putting it on the law firm website. They participated in interviews. I don't know. This is so crazy. This caused Relli to get several death threats on social media and otherwise. He's been the subject of ridicule and abuse and lost esteem in the community and has suffered extreme emotional distress. First off, cause of action is defamation against the Tacopina defendants and does 1 through 24. So I'm not going to read all that again. He's just kind of quoting everything that Tacopina said in these interviews. Second cause of action, defamation against Rocky and Doe's 25 through 50. So 25 each, all your employees. All those things. Because here's the thing. Rocky didn't say this stuff himself. But when you have an attorney, they ultimately are an agent of you. They act on your behalf. So he doesn't have anything that Rocky said directly. It's just Tacopina. Prayer for relief. Relli is looking for judgment against these defendants as follows. He wants damages, so he wants money in amount subject to proof for punitive damages as well. He wants money for the second cause of action. On all causes of action, he wants money, punitive and special. He wants the cost of the suit and for anything else. And ladies and gentlemen, Camille Vasquez signed. She signed this. Camille signed it, y'all. Fascinating. Oh. Larissa says side-eyeing Camille. I mean, she's such a great lawyer. But I don't know how you can look at this unless they have done their own discovery or have their own proof. Something about this is just so crazy. Is Relli telling the truth? Put a 1 in the chat if you think these lawsuits that Relli has filed. We just looked at both. And this is before we just got the result from last week, 2021 and 2022. Put a 1 if you think that these lawsuits have legs. Or put a 2 in the chat if you think after last week, they don't have legs. They're just legless. These lawsuits are legless. Lawsuit 1, legless. Lawsuit 2, legless. You are not moving. Irreparable damage. Crystal says 2. Kelly says 2. Natasha says 2. Mark says 2. Kelly Kell says 2. I was so surprised to see this, y'all. I really was. But, you know, Relli's got them scrapes. He's got them scrapes, those injuries. He wants money. Are y'all ready to talk about the diddler? Seeing a lot of 2s. Okay. We're switching gears. This is starting to become a little crazy with Diddy. Let's start with his lawyer quitting on Friday. Like there's so many updates on this one. He had a lawyer quit. And we are about how many weeks from his trial day? We're about 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. We're 10 weeks from trial. That's not a lot of time. That's less than, it's 2.5 months. That's not a lot of time. So let's go there. We're going to shift to Diddy time because obviously there's a huge Diddy docket. Another one of my favorite Twitter accounts to follow is the Diddy docket, where they talk about all things Diddy and they keep everybody up to date. Now let's look at this one. So this is an attorney that was representing Diddy. I hope I'm saying it right. I believe his last name is RICCO. RICCO. It looks a lot like RICCO. RICCO. So Anthony RICCO, the defendant Sean Combs, moves to this court before Honorable, I don't even know how to say that, the district judge in New York, at a time convenient for the judge for the following relief. This person filed this on Friday, and they want an order permitting this attorney to withdraw as attorney of record in the case. For such and other further relief, asked of this court may seem just and proper. They want to get out. They just want to get out of a case. Alexandra Shapiro staying on. Mark Agnifilo is staying on as well. Diddy got a copy of this. all the government prosecutors got a copy of this as well. RICCO, pursuant to Title 828 of the U.S. Code, hereby declares under the penalties of perjury. On September 22nd, I was retained by the defendant, Diddy, to serve as counsel, and I have served as his counsel since that time. As a result of being retained, a notice of appearance was filed in our court on September 29th, 7 days later. This declaration is submitted in support of Annex Notice of motion for my withdrawal as counsel as required under the court rules. They're saying Rule 1.4. I have to check that out later. For the reasons set forth below, this motion for withdrawal is filed so that Diddy may move forward with his defense and to commence jury selection and trial without any delay. That's huge, guys. The Diddy case is now moving to jury selection. Wow. And how do you get an unbiased jury in New York? In New York. How are we going to do that? Interesting. Reasons to be relieved as counsel for Diddy. So, as a result of discussions with lead counsel Mark Agandifilio, I want to say Filio, this motion for the withdrawal of counsel is filed. While I'm aware that the local rule requires an application for withdrawal of counsel is supported and granted only by showing an affidavit or otherwise satisfactory reasons for withdrawal, there are sufficient reasons related to the protections afforded by the attorney-client privilege. So he's not going to tell us. It's protected that he's withdrawing. For brevity in my application for withdrawal as counsel in this case. Although I have provided Diddy with a high level of legal representation expected by the court, under no circumstances can I continue to effectively serve as counsel for Diddy, consistent with ABA standards for criminal justice. That's crazy. He's saying, according to the rules that you guys have me under, I can no longer represent Diddy. I wonder why. This motion for withdrawal of counsel, if granted, will not only result in a delay of the present schedule for the commencement of jury selection and trial, or the present schedule for briefing of pre-trial legal issues. As a result, there will be no lapse in representation, as Diddy will continue to be represented by 5 other attorneys as of record. All right, so Diddy's still very much protected. Without violating any aspect of the attorney-client privilege or otherwise providing details whatsoever on the grounds supporting the application, the government has been notified of the motion to withdraw as counsel. So he let the other side know. The government takes no position in the motion seeking the withdrawal of counsel for Diddy. Wherefore, it is respectfully, but regrettably, requested that the court granted the relief requested in the annex notice of the motion and permit Anthony Rizzo to withdraw as attorney of record. So, sorry, you guys, I'm a little stuffy today. So this was filed on Friday. So one of his lawyers is leaving the case. Does it stop everything in its tracks? No, because he still has 5 other attorneys that are going to continue with the case. Withdrawals sometimes can be normal, but with us being this close to trial day, Cinco de Diddy, it is a little abnormal that somebody would drop this close to game day. Now, we are starting to see a ton of filings, and I think the flurry of filings are going to continue. It's going to start snowing. Winter is coming for Diddy. And they are going to start filing a ton of things, but really, they're going to start looking at the Department of Homeland Security's investigation, which it's the feds. Open and shut case, Johnson. They're pretty tight with the way that they conduct investigations. And so our next document leads us to something different. I noticed that we're starting to see motions to suppress evidence, things of the like, right? This one was filed last night. This is a motion to suppress evidence obtained through search warrants and the alternative for a Franks hearing. So they're requesting a Franks hearing. So Diddy, you can tell, although one lawyer has dropped, others are coming on. Why do people drop? They drop for conflicts of interest, personal issues. Sometimes you're fired and it can be masked as, you withdrawing from the case. Some things like that. Shout out to Paulette who says, hey, AV, Riso is my past mentor at university and friend. I've known him to be one of the most honorable attorneys. Name is sadly pronounced Rico, like YSL. Where's Rico? I don't. Okay, thank you, Paulette, for the clarification. And that's the thing. It's such a small world. Half the time we get like emails and comments from you guys when you do know some of these attorneys in these cases, right? I talked to a young lady the other day who's a content creator, or at least starting off her YouTube channel, and she knows Legal Eagle. Like she went to she went to law school with him. I'm like, girl, you better hit him up. Anywho, Rico, attorney Rico, thank you so much. I just didn't want to butcher it, so I try to do it in a fair way. Now, as I said, we're getting very close to trial day. So whatever we want out, court of public opinion, we're going to be on the outside looking in. So our best bet is to glean what we can from these court filings from both sides. We did that for a little bit with the YSL case when Woody said what he did on the stand, and we were essentially shut out of the courtroom for like 2 months. So what we were able to do is look at these court filings back and forth and go from there, right? Back to Diddy. So they want a Franks hearing. Take notice that upon declaration of Tony Geragos, dated February 18, the exhibits attached here to accompanying the memo of law, Diddy, buying through his lawyers, will move to this court at the United States Courthouse at a date and time to be determined for the court for an order suppressing the evidence and all fruits obtained from the following search warrants. Now, when you suppress evidence in criminal law, that means if there was a problem with a search and seizure of a property or evidence, it falls under this umbrella. There's this doctrine called fruit of the poisonous tree, right? You have a poisonous tree. If anything comes from that tree, any fruits from it, like a poisoned apple or whatever from this poisoned apple tree, all of it is tainted because the way that you obtain that evidence was not done properly or according to procedure. Now, in law school, I really enjoyed criminal procedure. There were two classes that I took. I took crim law, which is your basics of criminal law, and then criminal procedure, which is your concepts like fruit of the poisonous tree, stop and frisk, how police stop people, how police knock and announce and get items or things included in the search warrant. Look at ASAP Rocky and ASAP Relli. When they went into Rocky's house, although we saw all these junky things, we saw a nutcracker, we saw pictures of all this stuff, but those things were not to be taken as evidence. They were there solely to find a firearm, any ammunition, things that are related to a firearm. Sometimes you have things in plain view. If you've got your weed or your drugs out, it's a plain view, then something like that is something that police officers can confiscate if there's only one thing on search warrants and things of the like. Now, fruit of the poisonous tree. I'm hearing that Diddy really wants to keep his phone. All the tea, guys. His phone. What did he have on his phone? He is really concerned about pieces of evidence that were extracted from his phone, right? Everybody is talking about this rumor, and right now it's strictly a rumor of Diddy tapes that, as a plot of extortion, that Diddy might have tapes of people. Who's on the tapes? Are they afraid that it's going to get out? People are leaving the country. I don't know. We're going to check this out. I'm very curious. I find this case to be fascinating. And I'm going in this raw dog. Everybody's like, have you seen the documentary yet? Put a one in the chat if you've seen the Diddy documentaries and let me know which one. If you have not seen the Diddy documentaries, put a 2 in the chat. Doesn't mean you're biased or anything. I have not seen them because I want to go in with fresh eyes. Have you guys seen the documentaries? Pretty Esquire says one. Destin hasn't seen them yet. Gigi hasn't seen them yet. SWAT hasn't seen them yet. Paulette has not seen them yet. And Diana, a lot of you guys have not seen them yet. Chaka T, good to see you, has not seen them yet. The Fall of Diddy is the best one. Pretty Esquire says. Petty Pendergrass has not seen them. Breezy, yeah, baby, has not seen them. Nans. Kiki, not yet. Thank you so much. Kiki like Siri. Kiri like Siri. Sorry, my eyes. I'm getting old eyes. I saw the full Breakfast Club Takapita interview this morning drop, but I have not had an opportunity to review it yet. I'll probably do like a short video, and if I need to do a reaction, I'll share that with y'all. But shout out to Wilson, says getting my info for you and lead attorney or from us. Yeah, we good. Kiri like Siri. I got it, Kiri. But yeah, so that's the thing. You know, this is going to start heating up. And I just want to start like really rocking with you guys a little bit harder with these legal docs. I know sometimes they're boring and they're dry. I'm going to try to cut out the fluff and get to the heart of these documents. Like, you know, like a little swordswoman, like Arya Stark, like, like just, you know, cutting through it to get you the stuff because it's going to start dropping more and more and more. Luckily, I'm plugged into the New York legal system now, so I can like start downloading documents and all that for you guys because they're starting to pile up, and they're going to pile up fast leading up to these next 8 weeks. So while we don't have eyes in the courtroom, we got eyes on the docs for sure, for sure. Anyway, long-winded way of talking about the fruit of the poisonous tree. Now let's see what the Diddy team is trying to get out of these. They want to suppress the evidence and all the fruits obtained from these search warrants. It includes a number of things. The first one, the January 4th, 24 warrant to search Diddy's iCloud accounts. Because remember, guys, the raid happened in March of last year. So well before the feds had a warrant to search Diddy's phone. They were all up in Diddy's phone, fishing, looking at things, and they were trying to like see what they could find from his iCloud accounts. Now, this is why we have to be very careful with our phones. And I'm not telling you to hide evidence or whatever the case may be, but these are just not safe. Like nothing you have in here. Look at Relli. Relli deleted text. They got found. Like nothing in your phone is safe. Ever. Ever. So you have that. So there are 2 search warrants. One was from January 4th. Okay. Hang on. I think I got this little drawing tool. Yeah, January 4th. Oh, that's ugly. Whatever. Can we highlight it? We can highlight it. Yeah, I don't like that. Okay, let's keep going. All right, so January 4th is the first one. Then the second one is March 22nd. So January 4th, March 22nd, these are the search warrants that were issued. The March 22nd warrant was to search his LA house and to seize any evidence therein. All right, so that's the second one. The third one, March 22nd, to search his Miami house and seize any evidence therein. March 25th, to search his person. His person means him. Diddy, we're going to search your phones on January 4th. On the 22nd, we're going to hit your LA house and then your Miami house. And then on the 25th, 3 days later, we're going to search you, like your body. What do you have? And to seize and search 2 of your cell phones, referred to by the government as Combs number 1 and Combs number 2, and extract information from those phones. September 16th, this is your 5th one, a warrant to search his person again and to seize and search additional 2 of his cellular phones, referred to by the government as Combs number 3 and Combs number 4, and to extract information from those phones. And then on September 16th, a warrant to search Combs' room at the Park Hyatt Hotel and seize evidence obtained therein. Or 2, the alternative, granting a Franks hearing. All right, so there's a lot to unpack there. So you got the initial view at one of his iCloud accounts in January. Then you have the 2 raids in March, Miami, and then you have the LA home. Then after that, you pick Diddy up. You search Diddy himself, right? And then you have 2 phones that he had then. Remember, Diddy didn't go to jail and get booked until September of 2024. And in that, he had 2 additional phones. So now you're looking at 4 phones altogether that Diddy had. This ain't even 2 phones, it's 4. Now, September 16th, I believe, is the day he got arrested, and he was staying at the Park Hyatt Hotel, which I'm like, Diddy, you staying at the Hyatt? In the words of A$AP Rocky, is that a bum-ass hotel? I don't know. He's staying at the Hyatt. He was staying at the Hyatt. Bum-ass hotel, I think. I don't know. I think Hyatts are nice. And the alternative, they can get a Franks hearing. And we'll talk about a Franks hearing in a second. So there's that. That was filed last night. Right? Next. In addition to that, this is their memo. It's a little bit longer. This is supporting their memo to suppress evidence because of these search warrants. And they're asking for a Franks hearing. So, you know, they kind of go through what their argument is. They go through the facts. I'll go through the facts for y'all. But their argument is centered on 2 main things. 1, the government's warrant applications contain intentional or reckless deceptive statements and omissions. So Diddy is like, y'all lied in your warrants. You lied. You lied on me. Can't stop, won't stop. You lied on me. 2, the warrants were unconstitutionally broad. And this is my prediction for this as we continue. I think that Diddy's team is going to use constitutional rights as much as possible in their defense. We saw some 4th Amendment issues. We saw some 8th Amendment issues come up recently. But now as this case is heating up, we're going to see a lot more, a ton more, because they're really going to look at his rights being violated. That's the heart of criminal procedure. Were the warrants, good? Were the searches good? Things of the like. So let's just kind of backpedal here. When they say the applications contain deceptive statements, what are they talking about? They're saying that the warrants may not omit critical exculpatory evidence, so things that would clear him. That's not in the warrants. The government's warrants applications hid critical evidence regarding victim one's consent and financial motive. Well, Cassie, we talked about that one. I remember that. They were saying that they ended up finding videos of Cassie and Diddy together. And I believe it was on Cassie's phone. And she was like, they say she was complicit in this. I don't know, but we'll read it. We'll keep an open mind. Next, the government's warrant applications hid exculpatory evidence regarding the credibility of other witnesses. So there are others. The misstatements and omissions were material. So they left these things out of their search warrants, but the defense team is saying that they were material facts that should have been included. When it says the warrants were unconstitutionally broad, the 4th Amendment forbids general warrants, so they need to be very specific. And the warrants obtained by the government in this case were virtually limitless. So there were no limits or guardrails on them. And then lastly, they have their conclusion. So super fascinating document so far. That's your table of contents, table of authorities. These are all the cases they use. I'm going to try to breeze through this one, guys, and then we're going to get to some faniwillis news. The government has a duty of candor when it seeks warrants. The nature of proceeding mandates secrecy, so the process is not adversarial. Precisely for that reason, investigators have an obligation to present a fair picture of the evidence, including inculpatory and exculpatory facts. While investigators need not present a magistrate with every bit of evidence they have discovered, they must nonetheless include a reasonably even-handed account. And they cannot omit critical exculpatory facts that might undermine a finding of probable cause. The government in this case utterly failed to do so. It sought several warrants to search Mr. Combs' residences, his electronic devices, and his person, and it presented a grossly distorted picture of the facts. It included only inculpatory facts, and it excluded any critical exculpatory facts that was indisputably in its possession at the time. This is a big deal. And my understanding is that this document is extremely, guys, redacted. You see these big blocks on the screen? I did not do that. The government did. The government did. I kid you not, I went into the federal site that we use to pull documents. Federal cases, because this is a federal case, but also state-wise. As attorneys, you can go to another state and pull documents. I was able to do that with Rocky today and some other cases that I'm working on, looking at some of the Massachusetts cases. Was able to go and look for that. And I was surprised that this is a 30-page document. Almost every page is like this. And that is the nature of the crimes that are described here. Trafficking, they want to protect the victims, things like that. We're also hearing that there is victim 3 and 4 included in here. So those names are, they're also redacted and covered right now. But Diddy's team last week, and I did TikTok on this. If you don't follow me on TikTok, follow us at AV7 Legal. When I try to do quick things through the week, that's where I'll post it. But I did see a 1-page filing, and we posted about it on TikTok, where Diddy's team now wants to see the names. He wants the names to be named. Every victim, every witness, all of that. Pretty standard in trials. You get a witness list leading up to trial, so the attorneys can prepare for who those witnesses are and how they're going to question them, and any discovery related to those victims or witnesses that are going to be on the stand. We'll see. I mean, Cassie is expecting again. She's expecting, I believe, her 3rd child. So I don't know if she's going to testify in this case. Either way, we're not going to be able to see it because it's not going to be It's not going to be, televised. So that sucks. But let's keep going. So the government claimed victims were coerced into sex, but it failed to inform the magistrate that, see this, we don't know what the rest of the sentence says. It also failed to inform the magistrate that it possessed text messages between alleged victims and Diddy, blank, blank, blank. The applications were intentionally misleading, which at minimum requires a Frank's hearing. The warrants themselves were also grossly overbroad, on the theory that Diddy's entire life was a criminal enterprise. The government sought virtually limitless authority to seize any evidence related to that enterprise. All his digital devices and the information they contained, all information on his iCloud accounts, plus troves of records and items in his houses, almost none of which was contraband. Where Judge Nathan found similar warrants unconstitutional, here the government obtained authority to rummage at will among Diddy's private effects. They cited 2009 case. Perhaps most troublingly, the government received essential limitless authority to search Diddy's digital devices, which contained a vast trove of personal information. Oof. The Supreme Court and Second Circuit have repeatedly warned that it is especially important that digital device searches must be limited and particularized. The warrants here were not. Damn, they got access to everything in his phone. Imagine having access to everything in Diddy's phone, like all of it, like, oh. And it's not just one phone. It's 2 phones, 3 phones, 4 phones, 4 of Diddy's phones they had access. Ooh, imagine what was in there. What do y'all think were in there? What was in, what do you think would be found in a Diddy, just one Diddy phone? It would be a lot. Shout out to Trucker T Brooklyn, giving out memberships to the community, the Chatterhood. Koch brothers got a membership. Susie Q got a membership. Elliot got a membership. Nana got a membership. Keita G got a membership. Chi-Town, Petty Pendergrass probably cutting up. I can't even see it. I don't even know what would be in a Diddy phone, but I wouldn't be excited to have to review that. Freedom says Meek Mill screaming for more. Oh my God. Oh, shenanigans. Factual background. During its investigation, the government executed numerous search warrants. We got the January 4th one, March 22nd, LA, and then Miami. Both applications were on substantially identical affidavits sworn by SHI Special Agent Sean Quinn. 3 days later, the government obtained an additional search warrant to search Diddy himself, his person, and to seize and search 2 of his cell phones. The warrant sought to obtain evidence related to possible crimes of racketeering, sex trafficking, and obstruction of justice. The list of items to be seized at the residences was incredibly broad, spanning pages, including, among other categories, all digital devices within the residences. So this is interesting because, like we said, with Rocky's, it was like gun and anything related to a gun. That's all you can go and search for. Whereas in Diddy's house, it's like all of it, everything in there, whatever's electronic, go get it. Whatever looks like it might be slippery and has baby oil, go get it. Get all of it. So that's what they mean when they say overbroad. It's not specific enough. It's not specific enough. The list of information to be obtained from the devices was similarly broad. As detailed below, the warrant applications presented a grossly distorted picture of reality. The government had in its possession, for example, a variety of evidence, including, I bet you behind this block it says baby oil. But it also says, suggesting victim one's participation in the alleged freak-offs was voluntary and consensual, not coerced as the government suggested in its applications. Oh! I know what this is. That first block, we can insinuate that those were the Cassie videos, this first black block, suggesting victim one's participation in the alleged freak-offs is voluntary and consensual. If that was the iCloud account search warrant, that's probably where the videos came from. Interesting. Okay, so they're hiding more from us. The government claims blank was based primarily on statements from producer one, an utterly unreliable witness whose claims were contradicted by other evidence that the government failed to mention. So they have proof that somebody lied as a witness. And the government's obstruction allegations were based largely on text and statements taken out of context. A crucial part of the context being that it's hard to put it together when they blank everything. The affiant also failed to mention that nearly every witness he interviewed had blank, 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 giving them a financial motive to fabricate or embellish. I wonder if they're going to bring Tony Busby into all this. The probable cause statements were intentionally misleading, but it worked. The government got its warrants, leaked damaging information. Well, here's where they lost me. Leaked damaging information. We saw the Cassie video. I mean, we saw it. We saw the tape. And yes, the government probably leaked that. And then executed its military-style raids at Diddy's houses. Through its duplicity, The government obtained evidence and included multiple electronic devices with an enormous amount of information about his entire life, an enormous and unfair tactical advantage. It continues to press its advantage, obtaining an indictment and multiple additional warrants, which were also incredibly broad. This document's already stressing me out. We might have to skip some of this fluff. It says the government's warrant applications contain intentionally or recklessly deceptive statements and omissions, starting by saying warrant applications may not omit critical exculpatory evidence. You're not supposed to leave it out. And so there's probably a ton of case law as suspected here. Okay, they're giving us the rule of law as well. I want to know what the government did, but they're giving us that. Next, the government's warrant applications hid critical evidence regarding victim one's consent and financial motive. This is about Cassie. The core allegation in warrant applications, and indeed the government's entire case, is that Combs forced victim one to participate in freak-offs. In its March warrant applications to search the house, it stated, blah, blah, blah. That was in the warrant. This statement was based on the investigator's interview with victim one, which took place 5 years after the events. But the government unaccountably failed to inform the magistrate, blah, blah, blah. That's probably exculpatory information, both of which severely undermined its account. When it sought the warrants to search Diddy's houses, the government had already obtained one device from Cassie, or victim one, that contained, look at all this. Look at all that they just hid from us. What are we supposed to do with this? Come on. What the hell is this? And thank y'all for getting my likes right. It's 500 people watching here, 600 likes. Thank you. What am I can't even interpret this for y'all. If we can't watch a trial, look at this. I mean, I don't know. Maybe Diddy's team, they're on to something. What is this? Straight blocks. The government did not, in the warrant applications, or even inform the magistrate blank. Faced with the claim of coerced and forced sex, the blank is the sort of thing that any fact finder would wish to know. By the time it obtained warrants to search Diddy's residences, the government had already obtained. Look at it again. Why? I want to know what's going on. They don't want us to know anything, Chiba. Nothing. And this document's coming from Diddy's side. Imagine what the government's documents look like. The whole joint just gonna be blocked up like this, like the whole thing. Oh, there's an exhibit 10. We probably don't have access to that. Look at this next page. Exhibit 11. Look at this. Oh my God. This is like a whole page. Why did you even put this online? Wow. The government alleged, but failed to mention. The government alleged, but failed to mention. Like what? How am I supposed to read your arguments? More generally, even as their relationship deteriorated and the two managed a breakup, this sounds like I can't even read. Exhibit 23, Exhibit 24. What the hell? And then it's like you cannot even determine what the argument's going to be because it's just blacked out. They are important evidence. They show the context of the relationship, and they also blank. I mean, I don't know, guys. I don't know how we do this. They are the kind of thing that any magistrate judge would wish to know when reviewing a warrant application in a sex trafficking case. Yet the warrant applications cannot even hint, they did not contain a hint of them. They did not even inform the magistrate judge this evidence existed. They simply stated that, well, I don't know what it is. This was intentionally misleading. Oh, really? Blank contradicted victim one's later accounts and gave the investigator obvious reasons to doubt the veracity of the allegations. Interesting. Look at this next one. Here it is again. Look at this. Like, blank contradict the applications in other ways too. The application said 10 sentences that we can't read. The warrant also claimed blank. Once again, the government hid evidence to the contrary. For example, why would you leave that? For example, we can't read it. You can't read it. It says, for example, just blank. Okay, maybe some here in the footnotes. We have a little bit of tea. It says blank is a male escort service. As the motion to dismiss count 3 details, the service has been operating in the open for over a decade. Ooh. I didn't know male escort services exist. Is this a thing? This document is probably crazy damaging. As the government has since conceded in its disclosure letters, I mean, this is embarrassing to read to y'all at this point. The government hid evidence that Diddy at time discouraged blank from using so many drugs. Oh, who are you trying to tell to stop? Finally, the warrant contains no mention of victim one's financial motive to exaggerate and falsify, as the government knew. Look at all this. It looks like a flag. Thus provided an unusually strong motive to fabricate years of the underlying events. Blank suggests that years after her relationship, she changed her story in a way that would cause maximum potential damage to Diddy and thus gave him maximum incentive to agree to a large payment. This is exactly the sort of evidence that goes directly to the credibility of the witness, whose story provided the core of the government's applications. As courts around the country have held, evidence that undermines the credibility of a key witness must be revealed because a magistrate judge must be given the opportunity to assess the totality of the circumstances. Here, rather than reviewing the magistrate affair summary, the government hid exculpatory evidence to bolster its case. The warrant applications were calculated to mislead, omitting clearly critical evidence. So that second argument is interesting because all of it we could not see. It was just all like blocked out. But it seems to have something to do with Cassie and her account of the story. So, and some things that the evidence or the government not only left out, but just did not put in the warrant application. Because when you get a search warrant, it gets put in front of a judge. Or when you apply for one, the judge can approve or deny it, but you have to put information and evidence on both sides to lead a judge to believe that you have probable cause to search a home, a residence, somebody's phone, things of the like. What are those facts that lead up to having a judge approve that or not? Crazy. I just can't believe how much they blocked. The government's warrant applications, here's more blocks, hid critical evidence regarding credibility of other witnesses. The government also sought to corroborate victim one's allegations and make related allegations with statements from other witnesses and victims. Again, the government hid evidence undermining these witnesses' credibility and presenting misleading and selective accounts. We are not dealing here with omission of a few ancillary facts. This is a case of systematic deception. Sex worker 1. The government relied on the information from sex worker 1, who we know nothing about in the rest of the sentence. But sex worker 1 was also given has also given the government exculpatory information, none of which was included in the warrant applications. In its December 24th discovery letter, for example, the government revealed that, more blocks, these statements from a participant in the freak-offs undermine the allegations. We don't even know who participated in the damn freak-offs. And they corroborate. Can't see the rest of it. It is unclear when the government received this information. The government has only stated, can't see the rest of that sentence, something any investigator would have asked. It is also clear that the other exculpatory statements sex worker 1 made about no tea, they just don't want to give it to us. That is precisely why Frank's hearing is required, to learn more about what the government knew and when. Moreover, if the government was not aware of covering up more tea, it could have been aware it asked. Given the government's loose relationship with the truth throughout its warrant applications, the obvious inference is that the government was already aware of sex worker 1's exculpatory statements, but simply failed to include them in the applications. It did exactly what the Second Circuit forbids, merely informing the judge of inculpatory evidence. You got to do both. Now, we know about sex worker 1. We don't know much because of all this that they're hiding. Let's go to assistant 1, which is likely KK. The warrant applications relied on information about assistant 1, including, we don't know much. The application said assistant 1, they're not going to tell us. As with victim 1, the applications failed to disclose that, they're not going to tell us. But the applications were particularly misleading in their accounting of supposed obstruction of justice. They stated that Diddy had obstructed justice by blah, blah, blah. Look at that. I feel like, when people, if you're swearing, do you remember the censor button from like the 90s when you're watching TV and all of a sudden it's like, beep, like, all of a sudden, blah, 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 beep. Like, that's what I feel this document is doing. It's just, we can't see anything. But the government cherry-picked a couple of statements out of context to imply beep. But the complete and tread demonstrates the opposites. Beep, 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 beep. Like, look at the page. Look at the page. This is not harassing or threatening exchange. It was rather beep. Does not remotely make out the probable cause for the act of obstruction. But the government plucked a few quotes out of context and thus presented the magistrate judge with a completely distorted picture of what happened. This distortion cannot have been accidental. It was a deliberate choice. All right, so that has to do with KK, that whole section. Now we're going to talk about producer 1. I wonder if this is Little Rod. Yeah, it sounds like Little Rod. It says some of the most salacious allegations recounted in the warrant applications come from producer 1, who gave the government now says it will not even call to testify at trial. The investigator indicated he had interviewed producer 1, and producer 1 had relayed stories about his time working for Diddy. Producer 1 claimed, among other things, that beep. But the most serious and specific allegation from producer 1 was his claim that beep. The applications state beep, 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 beep. These accusations were never credible. They were uncorroborated. Beep. And the government had boatloads of contrary evidence, including beep. Like, what the hell? The government actually dropped these allegations in later warrants, but their lack of credibility was manifest from the outset. And the government once again failed to disclose producer 1's financial incentives to fabricate and embellish. Producer 1, beep, 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 beep. Nothing on page 14. Beep. The government has advised us it will not call producer 1, Little Rod, as a witness at Diddy's trial. Presumably, that is because his stories were fantastical and he lacks any credibility. But his lack of credibility was equally apparent in March 24th, in part based on beep. I'm guessing that is Little Rod's, like, when he filed his lawsuit. Because Lead and I read a lot of Little Rod stuff last year around that time. At a minimum, the warrant application should have disclosed beep, namely his motive to fabricate and tell a government story that matches the stories beep. I cannot. Once again, the government hid this from the magistrate. The investigator simply relied on producer one's claims without qualification, as if he were a credible witness. Now, look at this next part, guys. Victim two. The whole joint is just blocked. The whole thing. You know nothing about victim two. The whole thing. The whole thing is blocked. Now we get a victim three. This is new. The affidavits allege, based on interviews with victim three, that Diddy boop, like boop, 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 bleep. The relevance of these allegations is less clear. The claims about victim three appear under the header beep. In any event, the warrant applications once again exclude information. Look at all this. Victim four. This is a victim four. The warrant applications included allegations that victim four beep. The government made no effort to corroborate victim four's claims. If it had conducted a reasonably competent investigation, it would have obtained evidence contradicting her account, including, I think this is the lady that is involved with Jay-Z, or at least did that. The applications failed to note that I cannot. Designer one. The warrant applications also included allegations from designer one. I wonder who that is. The government also claimed that a representative of Diddy engaged in obstruction when beep. The applications failed to note that the context of, like, all of this is just hidden. So just skipping ahead here. Wait. Misstatements and omissions were material. I'm just gonna skip ahead, y'all. Like they're hiding too much. Talked about the warrants being constitutionally broad. The Fourth Amendment forbids general warrants. There's some case law to support that argument. I'm going to skip all that. The warrants obtained by the government in this case were virtually limitless. They were able to get evidence of Diddy's location, including anything that reflected the location of any co-conspirator or witness, which included, according to the government, seems to mean whoever worked with Diddy or went to a party. Damn. Well, that is big, because some people that went to these parties, I don't know. What if you went to the party and didn't do anything? But like Cat Williams told us what happens at Diddy parties. Some people can be first timers. But what this is showing us is like, they looked at the location of Diddy's phones. And to the government, it seems to mean that anyone who's ever worked for him or went to a party. They got utility bills, mail, address books, all calendars, financial records. Oh, any sex toys. Oh my God. Oh my God. Sexually suggestive clothing, medical supplies, or any materials related to sex. You, plus any bodily fluid. Oh God, you got somebody's jizz? What jizz? Oh, woo. Okay, that, woo. Wow. Plus any bodily fluid? Who keeps that? Oh. Or other material that might contain DNA evidence. Any communication or record of communications of any former sexual partner or employee of the Combs business, plus any communication related to the charged offenses, which was, as noted, very broad, with any possible victim, co-conspirators, or witnesses. Corporate records, ownership documents, employment records, any digital device that may contain evidence, including phones, computers, iPads, and cameras. Those descriptions were written with catch-all clauses. So it just means that they could take any of the things that were on that list, including your jizz. The government warrants to search Diddy's iCloud accounts and his cell phones were similarly broad. As to what information they can take, the government may just as well said everything. Everything. The iCloud warrant sought the ability to search anything stored on the accounts. The cell phone warrants, both initially in March and in subsequent September, sought all communications, photos, documents, calendars, location data, travel records, financial records, call logs, anything related to the subject offenses. But because of the subject offenses were defined as included all of Diddy's businesses, his household, his relationship with his girlfriends over the last 20 years, it's hard to think of anything that would have been related to the subject of offenses. That's interesting. They bring up another case where they're supporting their argument. The warrants here are even more infirm. They're just more of that. Conclusion. For the foregoing reasons, this court should suppress the evidence and all the fruits obtained from the warrants to search Combs's residence, his person, his iCloud account, and his devices. These warrants were unconstitutionally broad, and the alternative, and at the minimum, this court should order a Franks hearing to hear additional evidence and determine whether the warrants were improperly obtained through deception. Well then, ladies and gentlemen, there you have it. I mean, to take somebody's bodily fluids, what? Who's keeping them? I don't know. This is crazy work. I don't know. The nut juices. Oh, I gotta get out of here. Y'all are crazy. Y'all are crazy. All right, guys. Well, listen, this is supposed to be a quick power hour. Whenever there are no trials happening, I'm going to try to be here Mondays, Wednesdays, and Fridays afternoons at the same time. Tuesdays and Thursdays, we can look at some old stuff. Tomorrow is going to be a Karen Reed hearing. I think it's somewhere around 9 or 10 a.m. And then shout out to Kelly Kell, who has sent me the important parts of the Karen Reed trial. We're not watching the full 30 days. We're not. But I am going to, over these next, probably in 4 streams, I will break down the most important parts of that trial. Turtle Boy is coming next week. I'm going to be interviewing him about the trial. So if you don't know much about it, Turtle Boy is an investigative journalist here in Massachusetts that has been following this case from the beginning and helped get it national attention. It appears that Karen Reed might be being framed. And other people feel like she's guilty, but she is charged with murdering her boyfriend, who is a Boston cop, but he was at the home of a bunch of other law enforcement friends. It looked like they might have just gotten into a fight with the guy, thrown him out in the snow, and he died. She's on trial for second-degree murder. Her case happened last year, and when it did happen, it ended up in a hung jury. We learned from a hearing last week that there were many people on the jury that said for counts 1 and 3, they found her not guilty. The reason why it was a mistrial is because people couldn't agree on count 3 or count 2. So more on that tomorrow, and then we'll look at some highlights throughout the week of that case. But we're here Monday through Friday. Craziness. But shout out to everybody that donated to the stream. Spit and Fire. Very, very nice of you, sis. Thank you so much. Deandra popped in a few times. Shout out to Audrey. Great to see you, Audrey. Says, never want to go through Fulton. ASAP trial, in my opinion, was about jealousy and ego. That's right. We chopped that up. We talked about that. Trucker T gifted 5 memberships. Thank you so much for doing that, Trucker. Dan Deasy became a new member. Thank you so much, Dan Deasy. I hope you're going to love it here. And Nene, our favorite Aussie down under, has been a member for 5 months. Says you can keep that nut juice. 10 a.m. sis. She tells me what time it is because I'm always fascinated about the time difference. But anywho, Tyree says, AV, could it be blocked out for the public, but when it goes to court, they'll be able to read it? That is likely. That is likely, guys. It is likely that could happen. I think right now, because of the nature of this case, and there are victims that are involved with trafficking, the Department of Homeland Security is involved. They really want to, keep these names and solicitation of the victims quiet, because we saw that with Jane Doe, and it still was a Diddy case, but they included Jay-Z, and he's like, this is not fair. I'm a celebrity. Like, my name is out there. Can we get the victims' names? Can we get the other names? Can names be named? And the judge of that case said no. Shout out to Petty Pendergrass, guys. He is a mod on this channel and launching his YouTube channel. If y'all can check him out later, it seems that he will be going live. I always like to support other creators if you guys are here and wanting to grow. All right, y'all, I'm going to get out of here. Again, the link to the merch store is going to be in the description box. I love this shirt. I love it. It's so cute. 20% off with code STOP. All right, y'all, we will be back later on today and tomorrow. Stay safe out there. See you in the next one. Bye.